Stop. Good morning. I'd like to welcome you all to the Washington and Lee School of Law Journal of Energy, Climate, and the Environment's annual symposium. We appreciate that you all took the time to join us today. I think we have a really exciting lineup for you to discuss this year's topic, reclaiming environmental federalism. My name is Alex Lay. I'm the executive editor of the journal. We strive to create a forum for the legal community to discuss topics of the law that relate to energy and climate for both practitioners and for the academic community. We generally focus on topics such as resource extraction, energy generation and usage, climate change, and other environmental topics. Generally, our annual symposium is meant to enlist the aid of scholars and practitioners from around the country to discuss some of the most cutting-edge issues, and we hope that that's what we've done today. I'd like to take a few minutes to recognize and thank a few people. This year, the school has welcomed a new faculty member who graciously agreed to be our faculty advisor, Professor Jill Fraley. She's been an invaluable resource for the journal and the journal members, and we really are pleased to have her. Also, many faculty and staff members have worked behind the scenes to help us prepare for today, and I'd like to recognize a few of them. Wendy Rice, Tom Williams, Lynn Fitch, Steve Marmarella, Arthur Perry, the Associate Provost, Elizabeth Knapp, and the Deans of the Law School. Also, it goes without saying that we appreciate all of our panelists, commentators, and moderators for being here today and dedicating their time to our event. Finally, several of the members of the journal have spent tireless hours to make this symposium a hit. And I don't think anybody deserves more recognition for helping organize the event or really just contributing substantively to the topic more than this year's managing events editor Sam Petson. And I'm actually going to turn it over to him now to introduce this year's topic, reclaiming environmental federalism.
Thank you, everyone. Thank you, Alex, for the introduction to the journal and the symposium here. We're really thrilled to have you all here today. We have an audience also watching online, and we're very excited that folks have joined us online from all around the country. We have a broad audience. We have folks from energy companies, from utility companies, environmental organizations. It's an exciting collection of perspectives that are represented in the audience. But I would reiterate our enthusiasm and our thanks to the panelists. First and foremost, this panel, we're going to see two more excellent panels throughout the day. These folks are experts. They're in high demand. They can and do speak all around the country, in the world. I know that the journal and I think the community here is extremely grateful that they embraced this chance to join the JECE for this symposium. Recognizing the panel, I'm not going to make much of a preparatory statement here, just to say that the topic of reclaiming environmental federalism was an attempt by the journal to continue its efforts in recent years to address climate policy. Our symposia have dealt with federal climate policy at the outset of the Obama administration. We have targeted specific issues, as Alex suggested, resource extraction, mountaintop mining, offshore drilling over in recent years. Those have all been topics of our symposia. Reclaiming environmentalism, to us, is an effort to recognize that we have had federal legislative inaction on any sort of comprehensive legislation to limit or impose a price or a tax on greenhouse gas emissions. And we thought that at this juncture this year, it would be beneficial to consider how the law is reconciling itself to this situation of federal inaction on climate change. Businesses are moving forward, utilities, fuel producers are moving forward, and we think there are interesting, important questions about how the energy and environmental regulatory system in this country is responding to the situation. I would like to turn things over here to Professor Fraley. As you can see, we hope you linger for the other panels that will be occurring throughout the day, focusing on particular questions in the utility setting and the natural gas, shale gas production. There will be more about those panels as the day proceeds, but I want to reiterate our thanks for everyone for coming. I would also just remind people that the symposium is being streamed live on the internet. There are microphones in the room, so if we can that pick up ambient sounds, ambient noise. So if you can refrain from conversation, if you need to converse with your neighbor, please step outside. And the streaming will be going on throughout the day, including in between the panels. So bear that in mind. And don't defame your friends and whatnot. I'll be here throughout the day, and sitting in the front row here, and we have several journal staff. Please, if you have any questions, come down and present them to us, and we'll be glad to try to accommodate you. So without further ado, I think I would like to turn it over to David Bean, who will introduce Professor Fraley in this panel. Thank you all very much.
Good morning, my name is David Bean. I'll do a quick introduction of the panel. First, we have Professor Amy Stein, who comes from us from Tulane University School of Law. She previously taught at George Washington University, or the George Washington University, as an adjunct professor in environmental studies. Professor Stein, prior to entering the world of academia, focused on environmental litigation at Latham and Watt. Thank you. And her primary interests are in environmental law, energy law, and administrative law. In addition, we have Professor Robert Glicksman. Professor Glicksman is the J.B. and Marie C. Shapiro Professor of Environmental Law at the George Washington University. His expertise areas include environmental, natural resources, administrative, and property law. He has written numerous books in these areas, including the topics of climate change, federalism issues in environmental law, as well as also challenges facing federal land management agency issues. We also have here today Professor Robert V. Percival from the University of Maryland School of Law. Prior to that, he served as the senior attorney for the Environmental Defense Fund. Those of us that took environmental law here at WNL will recognize Professor Percival as the author of Environmental Regulation, Law, Science, and Policy, which we all know and love well. And he is a leader in conceptualizing the new field of global environmental law. We have with us here today Professor William Busby, Professor of Law from Emory University School of Law, and he is the director of Emory's Environmental and Natural Resources Law program, in addition to Emory's Center on Environmental and Intersystemic Governance. Professor Busby's scholarship focuses on the area of environmental law, administrative law, as well as other public law topics, and has particularly been focusing on regulatory federalism and design issues. In addition, we have Mr. Roger Martella, who is the is partner at Sidley Austin in Washington, D.C., a partner in the Environmental Practice Group. Prior or in between serving at Sidley Austin, Mr. Martella was the General Counsel of the United States Environmental Protection Agency In particular, Mr. Martella was counsel for the EPA during several landmark Supreme Court decisions, including Massachusetts versus EPA, Defenders of Wildlife versus EPA, EPA v. Rapinos, and Maine v. South District Warren. Mr. Martella focuses in several areas addressing climate change, promoting sustainability, and utilizing clean energy. And last but certainly not least, the moderator for this panel is none other than Professor Jill Fraley of our very own Washington & Lee. Prior to coming here to Washington & Lee, Professor Fraley taught at both Yale Universities and University of Kentucky School of Laws and has primary focus on property, environmental law, as well as legal history. Please give our panel a round of applause.
I'd like to add a very quick welcome this morning to all of you. And in particular, I would like to say thank you for our students who are here this morning. I know that between going to all of your classes, keeping up with your reading, and working on the job market, it can be a challenge sometimes to participate in the active intellectual life of your law school. So I really want to congratulate all of you on doing that and being here this morning. And I won't say any more. Mr. Martella is going to begin with a bit of background and introduction to federalism, which will give us a bit of a context for the remainder of our panelists this morning. We're going to stop periodically for questions, and I encourage you all to be very open and forthcoming with your questions. No need to be shy. Students, please participate as well as everyone else in the audience. And we look forward to taking your questions. Mr. Martella?
Well, thank you for those introductions, and I'd like to begin by thanking you for the honor of inviting me to participate with you this morning on what I cannot imagine is a more timely or more appropriate topic anywhere on environmental law than the notion of reclaiming federalism, and something I'm going to be touching upon. I'm sure the other panelists will be touching upon as well. Last night I was flying into Washington, D.C. around 7, 8 o'clock at night, and sitting next to me was my colleague from Sidley Austin, Carter Phillips, who's the head of our office, and some of you may recognize him. He's argued more cases in the Supreme Court than I think anyone else in private practice. And he was actually going back to the office, and he said, do you need a ride back to the office? And I immediately thought, Carter, I love you, but I'm not going to go to the office at 8 o'clock at night. But I said I had a good excuse. I said, I actually have to drive down to Lexington, Virginia. And he got this smile on his face immediately. He goes, oh, you're going to Washington and Lee? I said, yes, I'm going to go down and be part of the panel tomorrow. He said, well, I've been there several times. They've invited me down, and he had nothing but the highest regard for the opportunities he's had to come here, and he wanted to send his regards as well. And it reaffirmed to me, given Carter's high esteem for the school and the faculty here, what a privilege it is to have the opportunity to come to your beautiful campus. As things normally turn out in private practice, I didn't make it down last night. When I checked my BlackBerry, I got a call saying that I was needed urgently in a settlement meeting for a case that's going to trial perhaps on Tuesday after the holiday. And so I was able to rush down this morning, but unfortunately I apologize, I won't be here with you for most of the day. And frequently when I come to law schools, I like to be around to help law students to the extent they're looking for the perspectives of private practitioners, whether it's job market issues, career questions, things we can do to help you prepare for being an environmental lawyer, another type of lawyer in private practice or the government. And I'm sorry I won't be able to be here to do that, but you should have my contact information. And I would like to encourage you and not to be shy in reaching out to me if I can be helpful to you in any way, since I won't be here for most of the day. But with that, I would like to turn to the topic at hand, which is reclaiming federalism. And I think as some of the introductory remarks said, environmental law is in this state of transition where we're transitioning more to new issues that our old laws were not designed to explicitly address, like climate change, hydraulic fracturing, global pollution, and things like that. And so we're frequently talking about, and I think all the panelists are frequently grappling with, how do we take these old, perhaps even to some extent outdated laws and use them in ways to address new and emerging problems. And we frequently look at the text of the laws themselves and the provisions of the specific laws. How can we get this round peg to fit in this square box? But before we do that, we really have to step back beyond the specific words of a law and look at kind of what is the very foundation for our system of environmental laws in the United States. How are they implemented beyond the Clean Air Act and Clean Water Act? What is the approach in this country to addressing environmental law and environmental issues? And the common underlying theme, I believe, is cooperative federalism. Environmental law is based on a system of federalism. The two are hand in glove. And you can't read the text of any one environmental law without understanding the federalist system upon which it's based. And so what I wanted to do today was perhaps address three topics very briefly. I wanted to offer my perception and my view on what I think about when I'm talking about cooperative federalism in the environmental law context. It's a very basic definition of what I think is this underlying essence of our environmental laws. The second thing I want to do very briefly is kind of contrast that to some of the other leading environmental regimes in the world, because we can't really appreciate what we have here until we understand how other people do it differently, and perhaps not as well. And then third, and I think leading into the other abstracts that I've seen from this morning, I'm just going to highlight a couple examples of where we do need to reclaim federalism, because we're running into this problem today of whether our existing system can keep up with the emerging challenges. I'm going to give you four very short but specific examples of the last 24 months where our system of federalism is being tested in the environmental arena. But let me start with the first point, which is kind of what at least I don't want to speak for my other panelists. I've spoken with some of them before, and I think I can say that we probably agree on these basic concepts. But what do I think of when I'm talking about cooperative federalism in the environmental law context? And one of the things I'm really fortunate to do, even in private practice in the government, is get to go to other countries and to work on rule of law issues and help other nations set up their environmental law systems, as do my colleagues here on the panel. And frequently, whether you have 1 hour or whether you have 3 days, everybody wants to say, what does the Clean Air Act say? What does the Clean Water Act say? And people want to take vigorous notes about these laws so they can kind of duplicate them in their systems. And the very first thing I do, no matter how much time I have, no matter what class I'm teaching, is I start with the concept of federalism. And people maybe, they get a little surprised because they want to hear about the Clean Air Act. But I say you can't understand how U.S. laws work, the text of the laws, until you understand the U.S. system of cooperative federalism, because it means you can't just simply take our laws and stick them in another regime unless you understand the underlying bases. So the way I explain federalism in these contexts is twofold. First, I say you have to understand, beyond environmental issues, the U.S. system of the Constitution and the way we enact our laws, and that we have a Constitution of limited powers, and that the Constitution in no place, nowhere in the Constitution does it have a right to environmental laws, a right to the environment, does it protect the environment. The Constitution makes really no reference to the environment. But nonetheless, we have a system of environmental laws. The 10th Amendment, as you all know, prohibits the government from intruding into state powers. But our system for environmental laws derives out of the Commerce Clause and the broad power to regulate interstate commerce. And the converse of the Commerce Clause, and this comes back to our 4 examples in a few minutes, is that states cannot themselves regulate interstate commerce. So on the one hand, we have a source of authority. We have a source of authority that's not explicit in the Constitution, but is the basis for environmental laws, which is the Commerce Clause. And on the other hand, we have this tension that we shouldn't be regulating with state issues, and states also, on the other hand, are prohibited from interfering with the regulation of commerce themselves. So somewhere in the middle here, we see emerging our system of cooperative federalism. And I would basically define cooperative federalism in 4 distinct ways. The first premise of cooperative federalism in environmental law is that it's the federal government that sets the environmental laws, the environmental standards for the country. And one of the best known examples of this, one of the easiest to grasp, is the National Ambient Air Quality Standards. These are what we call NAAQS, and under the Clean Air Act, the federal government says for a given pollutant like ozone, the ambient concentrations of ozone anywhere in the country shall not exceed, 0.075 ppm or something like that. And so the federal government establishes the standards, establishes the laws. But what does the federal government do with that? And that leads to the second element of cooperative federalism. The government's preference is to delegate the responsibility for achieving that standard to the states. So we have the federal government enacting the law, but then on the second step, immediately delegating it to the states. And so we see this cooperative federalism approach, the government exercising its authority, but leaving it to the states to enact. But the government doesn't just leave it there. In many cases, if not most cases, Congress has authorized the states to, in the third step, to be more stringent than the federal government has set. So while the states have the ability to implement laws, and based on a delegation from the federal government, they can also decide as a matter of policy to be more stringent in the standards that they implement. So they can actually lower the NAAQS below 0.075 to 0.070, or in other cases make laws more stringent. There's exceptions to that, of course, but as a general policy, cooperative federalism entails a delegation to the states and the reservation of states to be more stringent. And then the fourth factor, which is increasingly becoming important, is the federal government doesn't just walk away from this. It doesn't say, okay, states, you can now do what you want to do. The federal government retains an oversight role. So if the states aren't stepping up, if they're not doing what they're supposed to be doing, if they're not properly exercising their delegation, the federal government is able to step in and take the program over, impose penalties, and so on and so on. So to me, these are the four core elements that are inherent in most of our environmental laws: the authority of the federal government, the delegation of the states reservation to make laws more strict and to enforce the laws, and the oversight of the federal government if the states don't act. And this is a system vastly different than almost anywhere else in the world. One of the areas where we're seeing kind of the greatest intensity of environmental laws emerging is China, for example. And China's system is almost the flip side of ours, where the federal government sets something, perhaps aspirational goals is the way we would look at it. They call them standards, but I think the closest translation to us would be aspirational goals. But really virtually all the authority, all the resources to implement and enforce and set environmental laws is with the provincial governments, what we call ministries of, EPBs, Environmental Protection Bureaus. And so it's almost entirely flip-flopped in China. So we can't go to China and say, take our Clean Air Act and implement it, because we have to adjust to a system that's, the mirror image of ours. And then a lot of times we think of the European Union, and the European Union likes to brag that it has the most stringent environmental system in the world. I frankly disagree with that. In some ways it is stronger than ours, but I think on the whole, the United States has the strongest commitment to environmental laws and protection. The European system makes all the other systems, I think, look relatively simple. And just to give you a couple examples, the European legislature does not even have the power to legislate. The legislation on environmental laws in Europe are not done through legislative means. There's no Administrative Procedure Act. Most laws are done ad hoc, and the European Union doesn't even have the authority to enforce its laws. So again, our system, I wanted to make this point because when we think of environmental law in the U.S. and we think of federalism, again, they're woven together. As important as the text of the law is as important as our system of federalism, which is different than anywhere else in the world. So with that, I finally want to turn to the question I think at hand for today, which is, do we need to reclaim environmental federalism? And I think the topic could not be any more timely, because I do think in the last 2 years, we've seen a number of significant challenges to this system. And I think we have to ask a couple key questions. Is the notion of federal enforcement, that fourth step, being exercised in the proper way? Can federalism adapt fast enough to new and emerging problems? Is federalism able to adjust to issues that are not necessarily anticipated in existing environmental laws? And to some extent, are states going beyond their authority and interfering with this kind of cooperative federalism between the federal and the state government? I'm not going to answer those questions definitively, but I am going to give you 4 examples where these questions are being raised by one side or the other. And the first question that's coming up, which happened about 2 years ago, in the summer of 2009, is the question of whether the government is properly exercising, the federal government is properly exercising its oversight authority. Is it really monitoring the states, or sometimes interfering with the states in their delegation? And the well-known example here was in the summer of 2009, EPA actually stepped into the state of Texas and took over the environmental permitting program for the state of Texas. The state of Texas for a very long time has had a very unique but powerful and effective what they call multi-pollutant permitting strategy, which is relatively unique to Texas. EPA's never really liked it, and over years they've had many back and forth conversations about whether to address some of the EPA concerns. And finally, about 2 years ago, EPA put its hands up and said, we're just not going to allow this anymore, and we're going to literally take over the permitting process in Texas because we don't think the system of cooperative federalism is working here. We're not happy with the way Texas is doing this. So this has raised a fair amount of controversy on a number of levels, and I think it's perhaps, to date, the most kind of direct clash of our federalism principles between the federal government and any particular state on environmental issues, and still being played out in the courts right now, and to some extent it was being played out in the political sphere, although it's, that's slowed down a little bit with Governor Perry no longer pursuing the candidacy. The second question is whether federalism can actually respond fast enough. And again, this is another example from 2009, it'll probably be talked about later this morning, where EPA was on the verge of implementing climate change regulations for the first time on January 1st, 2010. However, while EPA was able to get its regulations up to speed, many of the states, which had delegated programs, were not able to adjust their regulations in time in advance of this January 1st deadline because they have to go through notice and comment processes, public notices. In some cases, a legislature needs to change a rule, and a legislature may only meet once a year, maybe once every other year, and they simply weren't going to be able to act in time to reconcile these rules to the EPA regulations. In that case, cooperative federalism just simply wasn't able to act fast enough. So what did EPA do? EPA actually had to pass an emergency regulation called a state implementation plan, where EPA literally injected its regulations into these state regulations before the states could actually act, and it provided kind of a temporary basis. Again, this was unprecedented at the time. There's really been no examples where EPA previously had kind of the wholesale measure used this SIP mechanism to impose federal policies and state implementation plans. And so this raised a question about whether federalism there is actually responsive enough or actually had become a hindrance to pursuing those goals. The third question is whether federalism can adapt to new and emerging issues. And here we have a very timely issue right now that's moving ahead before us in the next couple of weeks, which is a rule that EPA promulgated over the summer called the Cross-State Air Pollution Rule. And this rule is relatively unique because what it does is it allows EPA to hold one state accountable for the pollution it's causing downwind in another state. And so we have, this very unique circumstance where EPA is no longer just looking state by state at regulations, but looking at how one state's influencing another state and imposing requirements on one state, like such as Texas, not because of the Texas emissions, but because of the way the Texas emissions may be impacting Illinois. And because of this unique multi-border jurisdictional issue, it doesn't quite fit with our cooperative federalism model. You can see that where it's usually state, EPA. To have state, EPA doesn't fit with that model. And so again, EPA has had to use some new legal techniques called a federal implementation plan to kind of put this round peg in a square hole. Back in December, the DC Circuit actually stayed EPA from implementing this rule, and what may be perhaps the only second time the DC Circuit has ever stayed any EPA rulemaking. And the court's going to be having oral argument on this in April. Papers were just filed last week. So this is being played out as we speak. This fifth argument, raising the cooperative federalism issues, is one of the lead arguments. You can read the briefs. I can send them to you if you want. And this is going to be argued in April. And we should have a decision from the court, I think, before the end of the summer. And then finally, my fourth question for you is, what about the reverse side of this? What happens when a state wants to do more than what's been delegated to it by the federal government? We talked about the fact that the Commerce Clause is not only an authority for the federal government, but also a restriction on states. And here we have a very recent example raising this issue. In December of last year, December 2010, a district court in California held that California's efforts to regulate the carbon content of fuels, a low carbon fuel standard, basically saying that California wanted to see lower carbon in fuels and more renewable fuels, actually violated the Interstate Commerce Clause, because basically California was regulating not just fuels inside of California, but fuels beyond the reach of California that were being imported to California. And the court held, I don't think the court referenced the federalism precisely, but the court basically held in the federalism type concept that California lacked the authority, even though the regulations only applied in California, to have an impact that went beyond the reach of the borders. And so this is a very recent example. Just last Friday, a week ago today, California sought an emergency stay of this decision to the Ninth Circuit. The industry, I'm part of this case, the industry groups will be filing their responses in the next couple weeks. And so we'll see a decision, maybe within a month from California, from the Ninth Circuit on how they're going to address this issue. So with that, that's my introduction to hopefully the concepts that are going to be some of the themes of this morning. And again, I'm sorry I won't be able to stay for the whole morning, but please do not hesitate to reach out if there's anything I can do to be helpful. Thank you, Professor.
Questions for Mr. Martello?
Could you just tell us a little bit about working after Massachusetts versus EPA, when EPA kind of reluctantly was forced to start regulating greenhouse gases, and how the process internally, to the extent you can, internally how the process of implementation developed?
Sure. And it's a fascinating question. If you could, for the geeks among us, it'd be a good book, actually. And I'd be happy to share some of that. I would just caveat it by saying there are some attorney-client aspects of that. So anything I share with you is going to be public record. Either someone else has said it, or it's been exposed as part of a congressional oversight. And basically, for those who are familiar with it, there's very few emails that haven't been somehow posted on some website at this point. So it is an interesting story, because after Mass versus EPA, the court, as many folks know, held that EPA had to make a decision on whether to address greenhouse gases under the Clean Air Act. And a lot of people walk away with the general proposition that the Bush administration immediately was unwilling to do so, and that it wasn't until the Obama administration that they were going to take some action. And that's partially true, but there's a kind of an unreported story in there that actually in the aftermath of Massachusetts versus EPA, the Bush administration actually did decide to go ahead and address greenhouse gases under the Clean Air Act. President Bush, about a month later, stood up in the Rose Garden, and I was there with him when he made an announcement that in response, the administration was going to address greenhouse gases from cars in response to the decision, and proceed with an endangerment determination regarding greenhouse gases. There were some intervening events after that which caused the president to reconsider his view on that. There were two primary intervening events. One was that Congress, in December of 2008, passed a law called the Energy Independent Security Act, which effectively did everything that the president was proposing to do. It was going to reduce greenhouse gases from cars by promoting renewable fuels and increasing kind of the fuel efficiency of cars. So what President Bush was trying to do through regulations, Congress had enacted through legislation. Didn't necessarily solve the problem created by Massachusetts versus EPA, but it achieved the same exact policy goal. The other thing that happened was that, that as folks like me and others looked at this harder and harder, we came to realize that the president's direction was not as simple as we thought, that in fact, merely regulating greenhouse gases from cars was going to trigger a whole cascade of other issues going to manufacturing and power plants and other types of facilities that we could not contain at the time. So given the passage of the law and this realization, the president ultimately decided to defer the regulation of the Clean Air Act. He continued to proceed to study the issue, and there was a very famous thing called the Notice of Proposed Rulemaking, which was this Bible of how you could regulate greenhouse gases, which in turn the Obama administration used when they came into office, and was able to very quickly propose regulations and came up with their own kind of approach to how to contain the cascade of the consequences that President Bush was concerned about.
Other questions? Okay. We can come back to questions for panelists later, as we'll have several different opportunities, but right now we'll move on to Professor Percival.
Put up my PowerPoint, I want to again thank you all for inviting me here, and also to congratulate the organizers of the symposium for assembling such a distinguished group of other panelists. I'm going to talk a little bit about the history of interstate pollution disputes among states. Before I do, though, you all know where this is. I actually took this photo from a plane landing at National Airport. That's where the president lives. That's where EPA is located. For 33 years, I've lived on Capitol Hill, right about there. And every time I talk about federalism, of course, it's a very hot issue today. You go to any Tea Party websites, and this is what you see. Some of the other websites are a little more graphic about EPA. It's trying to control your life. And actually, it kind of puzzles me because the original Tea Party was about one thing: taxation without representation. And although the party claims that it's nonpartisan, non-political, the number one issue, I would think, if you're concerned about federalism, is the fact that where I live, we have no voting representation in Congress. And that's a complete outrage from the standpoint about federalism. So I always feel a moral responsibility to point that out whenever I'm talking about federalism or to the Federalist Society. Now today I'm going to talk about the history of the common law, federal common law of interstate nuisance. And in particular, 3 recent cases that involve coal, climate, and carp. These 3 cases are North Carolina versus TVA, where a state common law nuisance action was brought by the state of North Carolina against emissions from coal-fired power plants in Tennessee, Alabama, and Kentucky. Also talk about the American Electric Power case that was decided by the Supreme Court in June, where a group of eastern states were suing Midwestern electric utilities for their emissions of greenhouse gases. And finally, the post-AEP litigation that's been going on in the 7th Circuit about efforts to try to stop invasive Asian carp from reaching the Great Lakes and destroying the ecosystem. Now, those of you who've taken environmental law from Professor Fraley, I know she has a hard time with a 2-credit course, but in my casebook, we start off by emphasizing these old interstate nuisance cases. Before we had comprehensive federal environmental laws, the states had some bitter interstate pollution disputes, and the only way those could be resolved was by the U.S. Supreme Court hearing these disputes within its original jurisdiction. And the first of these disputes involved the diversion of the Chicago River. For years, Chicago, like other cities, had just dumped its raw sewage in the nearest body of water, which was Lake Michigan, and it caused enormous health problems because it just sort of sat there. So they decided to build the largest public works project in American history at the time to reverse the flow of the Chicago River so that it would flow into the Mississippi River, which meant that the citizens of St. Louis, who got their drinking water from the Mississippi River, were eventually going to be drinking the product of Chicago's sewage disposal. So Chicago filed suit in the U.S., Illinois filed suit, Missouri filed suit against Illinois in the U.S. Supreme Court, asking them to stop Chicago from dumping its sewage in this drainage canal that had been built. And the court heard evidence, the canal was opened in 1900, heard evidence for 5 years. Missouri tried to prove that there had been an increase in typhoid fever deaths since the canal was opened in 1900. But as this chart shows, there was something else also going on long before that to influence that. And the court ultimately said, you haven't shown enough evidence that this is really causing harm. And besides, Missouri's own cities are doing the same thing, discharging their raw sewage in the nearest body of water. So they refused to grant an injunction. But the first time the Supreme Court stepped in with an injunction was in the Georgia versus Tennessee copper case in 1907, where a copper smelter, 2 copper smelters located north of the Georgia border in Tennessee were, like all other smelters at the time, they had no pollution control at all. And the result was that they had destroyed the landscape for miles around because the emissions of the pollution destroyed all vegetation. So causation wasn't an issue. And eventually the Supreme Court actually stepped in and wrote an air pollution control injunction. It didn't shut the smelters down, but it required them to reduce their emissions during the growing season, and put a lot of pressure on them to develop what ultimately became the first pollution control technology for those smelters. Then we got subsequent cases. New Jersey and New York were fighting over sewage disposal in New York Bay and ocean dumping of garbage. Supreme Court stepped in and actually required New York City to build its first garbage incinerator so it could stop ocean dumping of garbage. And the ironic denouement of the Missouri versus Illinois litigation is that eventually as the city of Chicago grew, it had so much raw sewage it had to flush away that it was taking so much water from Lake Michigan that it was lowering the level of the Great Lakes by about ½ a foot. So the states in the Great Lakes joined Wisconsin in suing Illinois, and this time Missouri came to Illinois' defense, but the Supreme Court ultimately ordered Chicago to build its first sewage treatment plant so that it could stop taking so much water from Lake Michigan. The Supreme Court didn't like hearing these cases because it realized that it had no special expertise in deciding what were appropriate levels of pollution. So after we had the great surge of political support for environmental protection in the early 70s, and Congress stepped in and enacted all these laws, it's not surprising that the court was eager to turn it over to EPA the task of arbitrating these interstate pollution disputes. And in the Milwaukee 2 case in 1981, where Illinois was suing Milwaukee because of the impact of its sewage on Lake Michigan, Supreme Court ultimately held that the Clean Water Act, because it was so comprehensive, had preempted the federal common law of interstate nuisance. And then in a subsequent case involving pollution of Lake Champlain between New York plaintiffs in Vermont and a New York paper mill, the Supreme Court held that while the federal common law of interstate nuisance was preempted by the Clean Water Act, state common law still could be used so long as you applied the law of the source state. Now, fit the new interstate nuisance cases into that framework. The first of them being North Carolina versus TVA. Here in North Carolina, after adopting fairly stringent pollution laws for emissions from its power plants, realized that it was still having a hard time meeting the national ambient air quality standards that Roger talked about because of transboundary pollution from all these old coal-fired power plants, many of them operated by the Tennessee Valley Authority. So they brought a state common law nuisance action, and of course under the rule of Aulet, the applicable law was the law of the source states, and they sued all these plants, including TVA's Widow Creek Power Plant. They actually sued 11 TVA coal-fired power plants, and after a lengthy trial in federal district court in North Carolina, the federal district judge ruled that they had succeeded in proving that even if these plants were in compliance with their Clean Air Act permits, they were still causing significant harm to public health and welfare in North Carolina because of the transboundary pollutants. A lot of them had been grandfathered in the original Clean Air Act, so they didn't have scrubbers and the like. The judge said that 7 of the plants were too far away for them to meet the standard of proving causation. But he ordered that 3 of the plants in Tennessee and 1 in Alabama had to install scrubbers and new pollution control technology to reduce the harm that they were causing in North Carolina. Then, however, the case is appealed by the TVA to the U.S. Court of Appeals for the Fourth Circuit in a decision authored by Judge J. Harvey Wilkinson. The court said that the decision should be reversed because the plants were already complying with their permits, and it would cause chaos if we allowed federal judges to use common law to impose their own standards on these plants. Now, I think this is fundamentally wrong because the common law has always served as a backstop. That even if you're in compliance with regulations, if it can be proven, and it's really hard to prove, that you're causing significant foreseeable causal injury to someone else, the common law should be able to step in. Well, this case was then, certiorari was sought before the U.S. Supreme Court, and we'll talk about how that came out in a moment. Second case involving climate was the lawsuit by Connecticut and other eastern states against several electric utilities for their emissions of greenhouse gases. Now, while the assumption was that for things that are already regulated, the federal common law may be preempted, since greenhouse gases were not being regulated by EPA, and at the time EPA took the position, had no authority to do so. This lawsuit asked a federal judge in New York to require gradual reductions in the amount of emissions of greenhouse gases from these power plants. However, in 2005, Federal District Judge Preska in New York dismissed it all as a non-justiciable political question because she said it would force her to be imposing regulations on greenhouse gases, and that was not the job of the court. That case then got appealed to the Second Circuit, and the Second Circuit sat on it for a very long time, in part to await the Supreme Court's decision in Massachusetts versus EPA. And as you know, by a 5-4 vote, the court said that EPA had to consider making an endangerment finding that greenhouse gas emissions could be regulated under the Clean Air Act and should be regulated if they were endangering public health and welfare. Then, 2 years later, the 3-judge panel hearing the appeal, minus Judge Sotomayor, who had to leave because she got appointed to the Supreme Court, reversed the district court decision, said it's not a political question, the plaintiffs have standing, and the lawsuit is not preempted by the Clean Air Act because EPA is not regulating emissions of greenhouse gases. Well, EPA then, under President Obama and Administrator Jackson, started to regulate them, made the endangerment finding in December 2009, and as a result, when the case got to the U.S. Supreme Court last June, the court held that the federal common law of interstate nuisance was preempted because Congress had delegated to EPA the task of regulating greenhouse gas emissions. Now, the third case involving the invasive Asian carp is the first case that's been decided by any federal appellate court since the American Electric Power decision. Asian carp originally were brought into fish farms in Arkansas, but they escaped and they started working their way up the Mississippi, and they tend to dominate the ecosystem and cause a lot of ecological damage as an invasive species. As a result, the Great Lakes states brought suit to require Illinois to shut the very drainage canal that it had built back in 1900 that was the subject of Missouri versus Illinois. The Corps of Engineers has tried to have electronic barriers erected, but it's not clear that those have been successful because the DNA of the Asian carp has been found upstream of the electronic barriers. So the Great Lakes states are petrified that they will suffer the invasion of the Asian carp unless the court steps in. The American Electric Power decision raised the question, well, if the Clean Air Act preempts a regulation of greenhouse gas emissions because it gives that task to EPA, does the Clean Water Act preempt a federal common law nuisance action for an invasive species? And the U.S. Court of Appeals for the Seventh Circuit in 2011 ruled that it did not. That because the invasive species problem is one that Congress had not addressed through regulatory authorities in the Clean Water Act, the federal common law of interstate nuisance should still be available. Nonetheless, the court refused to grant the request to order Illinois to build or shut down the drainage canal to stop the carp, but in an opinion by Judge Diane Wood, the court said they would monitor the situation very carefully to see if there's any problem. Now, what lessons can we derive from this? Well, the use of the federal common law back at the beginning of the 20th century actually was successful in getting the first new pollution control technology, the lead acid chamber method, for controlling pollution from smelters because of the fear that eventually, if the pollution continued, the court might shut down those smelters. With respect to the TVA decision, after the petition for cert was filed, and it looked like EPA would weigh in with the Solicitor General and was very skeptical of Judge Wilkinson's decision, a settlement was reached where the Tennessee Valley Authority agreed to close down some of those old power plants to install new state-of-the-art pollution control technologies on others, and as a result, achieved even more relief by settlement than the district court had ordered. Unfortunately, this keeps the Fourth Circuit decision in place as a precedent, which I think was wrongly decided, but because of this litigation, the settlement was achieved that will lead to greater pollution reductions than the plaintiffs had originally been seeking. Now we know today that the Republicans in the House of Representatives, seems like every week they have some new way of proposing to cut back on environmental regulations. Congressman Waxman's staff calculated that there were about 250 anti-environmental votes, more than one per day Congress was in session last year. And one of the things they'd like to do is to deprive EPA of the authority to control greenhouse gas emissions. Well, I submit that under the American Electric Power decision, if they're successful in that, then the federal common law of interstate nuisance will be back into play, because the whole logic of the AEP decision is that, in fact, the Clean Air Act gives EPA the authority to regulate greenhouse gas emissions. So if it does not do that, then the federal common law could be resuscitated. Now, of course, Congress could, if it wanted to, if the Republicans sweep the Senate and also take the presidency, also displace the common law with other legislation, but that would require a pretty big stretch for a lot of people concerned about federalism if they were going to preempt this tool that has been an essential tool of the states for dealing with pollution problems that are not adequately addressed by existing law. So in conclusion, I would say that reports of the death of the federal common law of interstate nuisance are premature. It is in fact playing its appropriate role as a backstop when our regulatory institutions fail to deal with important transboundary pollution problems. Thank you.
I have to add for my students that I'm very happy that Professor Percival has defended my decision in a 2-credit course to make you all study nuisance, despite the fact that we had to switch down to so few things. We are going to take the last 4 papers 2 at a time and then allow for questions after each set of 2. So right now we will go ahead with Professor Amy Stein.
Thank you, Jill, and thanks to all of you for being here, and of course to Washington and Lee for organizing this conference on such an important topic. Now I'm going to talk about another area of our system where federalism is being tested, as Mr. Martella has laid out for us. I hope to spark some interest this morning in the often underappreciated topic of infrastructure siting. Don't roll your eyes yet. It may not sound sexy at first, but if you think about it, siting is, in our country, it is rife with federalism controversies. The most high-profile federalism siting controversies have involved Congress's attempts to alter the balance of power between the states and the federal government regarding what? The one-time big high-impact sightings of a repository for our nation's high-level nuclear waste facility at Yucca Mountain, Nevada. And more recently, of course, if you pick up the paper, the sighting of a 1,600-mile Keystone XL oil pipeline that would run from Canada through 6 states, the heartland of our nation, down to Texas. So siting can be interesting, and by siting I mean the decision to construct additional infrastructure, a process that usually involves 2 things. 1, a determination that the project is needed, and 2, approvals of the specifics regarding the location. So of course, because this is a federalism conference, you can be sure I am interested in who is in the best position to directly impact the decision to construct this additional infrastructure. Now, in many ways, although the highly controversial decisions get the most attention in the public media, I assert that in many ways the more important siting decisions are those that occur on a regular basis. The more mundane, boring, commonplace siting, think railroad tracks and facilities, telecommunication towers and fiber optic cables, natural gas pipelines, electricity transmission lines, and of course the siting of the generators that actually power our electric grid. As opposed to the one-time big-ticket sightings, these repetitive decisions occur more frequently, often under the radar, and often elicit controversy only to those that are living closest to the siting. Within that world of infrastructure, the hot topics of energy federalism often involve the siting of transmission lines. Many of you may have heard discussions about this already, determinations about whether and where to place transmission lines, remain largely under state or local control. I will talk in a moment about FERC's ineffective backstop authority, but many point to this state or local control as an obstacle to the development of more transmission, which in turn can connect more diverse sources to our grid, which in turn can enhance reliability, as well as provide a necessary path for renewables that are often located in more remote locations, far from the existing grid. But my presentation today is not about the siting of transmission lines, it's instead about the siting of the actual power plants themselves, the generation. You know, whether that be a coal plant, a natural gas plant, or even renewable energy generation. This seems to be an often overlooked aspect of the federalism discussions that I think is worthy of some attention. Now, as with transmission lines, state or localities have exclusive control over the siting decisions regarding generation under the Federal Power Act. There are exceptions for the siting of generation for nuclear and hydropower, but other than that, we leave it up to the state or locality to determine whether its power needs are met through coal, natural gas, wind, energy efficiency, or other methods. Now, for many of you, state or local control over the type of electricity generation is not surprising and is in fact expected. After all, the siting of infrastructure is a land use decision. And any of you from your basic classes know this is an area of traditionally local nature, one that the courts have recognized as such. Now, state or local control over the siting functioned adequately, more or less, for over 70 years under the Federal Power Act. But as the nation finds itself faced with increasingly important decisions that directly implicate the source of our electricity, including climate change, I question whether the proper functioning of this exclusive control is becoming strained. In the short time we have together, I will just talk about three things. First, I want to highlight the disparity in control between the siting over electricity generation and the siting over those other types of commonplace infrastructure. Second, I take issue with the prevailing theories that can be used to help explain this disparity. I just found them very unsatisfactory, and so it made me look for more, and that will be my third point, which is that I'm going to provide you a flavor of the historical analysis that I have conducted to try to look for if there are other unappreciated variables that are impacting this potential tip from state to a more enhanced federal rule. So my first point is that all of these commonplace regimes have tipped towards some form of more enhanced federal control, except for the siting of electricity generation. Railroads, telecommunications, natural gas pipelines, and electricity transmission lines all began under state or local control. But at some point in history, they have all tipped towards an injection of more federal involvement. Now, I call it enhanced federal control because, of course, there can be different ways that the federal government has become involved. In 1920, Congress passed the Transportation Act that consolidated exclusive siting authority over new rail lines and facilities in the Interstate Commerce Commission. In 1938, Congress enacted the Natural Gas Act, providing exclusive federal authority over the siting of pipelines with FERC. In 1996, we get more of a partial federal involvement, where Congress passed the Telecommunications Act, preempting state siting authority over wireless communication infrastructure in a way that there's partial preemption if the states try to in any way discriminate amongst providers, have the effect of prohibiting wireless service, or regulate on the basis of environmental effects that differ from local regulations. Then in 2005, we get another sort of partial tip. Congress passed the Energy Policy Act of 2005, part of which finally provided FERC with some sort of backstop authority, it's called, over the siting of transmission lines. In very narrow circumstances, in areas of the country the Department of Energy has designated as high congestion areas, and only where a state withholds approval on a transmission line application. So the only commonplace siting regime of all of these that has not tipped is the siting of the generation itself. Now, given some apparent similarities between these siting regimes, what explains the state control over electricity siting and a tip toward an enhanced federal role for the rest of the siting regimes? Although a number of theories, of course, can be invoked to try to explain this, right? Some just say it's politics, right? Short and simple, that's why. Some say there's no way in this political climate are we going to reopen such issues and amend the Federal Power Act to take this power away from the states. But you know, and all of these theories that are thrown out there, three sort of came to the surface as being potential ones. The first option is that traditionally local activities should remain in the hands of the state and local governments. A second theory is based on federalism virtues themselves, right? The idea that the level of the government controlling these siting decisions is that which will best advance our system of federalism. And the third option is that maybe this disparity is just explained by public choice theory. As the result of self-interested legislators acting in a way to maximize their wealth, and that this could maybe explain the disparity. I just found none of them to be entirely satisfactory. I mean, when you look at the traditionally local argument, all these other areas of the law experience the exact same historical presumption of local control. So why is it that in those situations, there was still enough something else to overcome this presumption of local control? On the federalism virtue side, scholars and judges have coalesced around this package of abstract virtues that are associated with either the benefits of state authority or the benefits of federal centralized authority. You're probably familiar with these, but right, the state and local authority, decentralized virtues include things like a better ability for the public to participate in our democracy, and better accountability, the famous ability of states to serve as laboratories for experimentation, that the states are in a better position to protect the citizens' health and welfare, and better realize cultural and local diversity, and the ability to diffuse power and enhance liberty. Conversely, on the centralized side of the federalism virtue ledger, we get benefits of a federal authority in that it can provide uniformity across the nation when needed. Particularly the ability, as Professor Percival has said, to address transboundary issues across state lines that create externalities. A third reason being that minimum federal standards can prevent a race to the bottom between the states. And the last one being that federal government can be more effective at addressing public goods. Now, these virtues have merit in different circumstances, but I found them to have explanatory limits when you try to use them to explain discrepancies in tips from state control to federal control. For instance, first, the virtues rarely line up neatly on one side of the federalism ledger. So what happens when you have an area of the law and it has transboundary issues, which suggests maybe we should get the federal government involved, but then this is an area of the law that will really benefit from state and local experimentation, and we need to be able to use their diversity and respect it, so then what? It doesn't provide any sort of persuasive, there is no clear prevailing power level established by that. And second, even if the federalism virtues did line up neatly, kind of directing us that this should be an area for state control or this should be an area for federal control, it is far from absolute that the presence of these particular values and virtues renders the corresponding authority the best fit in all particular situations. For instance, you can probably think of a number of situations where perhaps the states are not in the best position to be protecting their health and welfare of their citizens, where perhaps there's issues of agency capture and particularly strong lobby in certain areas. So maybe that doesn't necessarily mean that even if we see those, then that we are going to truly realize those virtues of federalism by that particular allocation of power. The third sort of prevailing explanation that rose to the surface was the public choice theory. A lot of individuals and colleagues I talked to would always say, oh, it's just politics, and you look at transmission lines, and why did the federal government sort of get to be involved in 2005? Well, one of the former FERC commissioners has now left government and is now working for a company that really has a vested interest in getting transmission lines done. But that just also didn't quite satisfy me, so I looked at public choice theory as a variance of this. The public choice theory often is that we must always seek to understand political outcomes as a function of self-interested, wealth-maximizing individual behaviors. And the idea is that this theory can be applied to legislators, right? That legislators, they act, and we get political outcomes. It suggests that Congress will delegate to local regulators only when the political support it obtains from deferring to the states is greater than the political support it obtains from regulating it itself. Okay, this has some intuitive appeal, but again, the limits lie in using it in a comparative way, right? Because first, the drivers of legislative self-interest are far from uniform. Self-interest may drive some legislators to cater to voters if they're interested in re-election, But self-interest may also drive legislators to cater to their fellow legislators. What if it's not an election year and really they don't care about their pet project and so they're in the mode of vote trading? A second and related point is that there's no guarantee that this self-interest is correlated with a particular level of federalism authority. Right? It's not true that they will always opt for the status quo if they're looking for re-election, nor that they might always be in favor of state or localized control, depending on where their self-interest may lie. So although politics and special interests and moral commitments and federalism virtues, a host of other factors contributed to these decisions, I decided to look if I could see something a little more tangible. So I analyzed the history behind the tips towards federal control for railroads, telecommunications, natural gas, and electricity transmission. And I tried to see if there was any sort of commonality. Could I glean something from this analysis that would help? And at least 4, maybe I would call them underappreciated variables rose to the surface that I think can play a role in explaining the discrepancies between state control over the generation siting and an enhanced federal role in the rest. One is that threats to national security are more likely to elicit tips towards federal power. Since at least the Federalist Papers, danger has always been a justification for federal involvement. Some attribute the tip towards federal power over railroads to what was going on regarding World War I. Passed in 1920, the Transportation Act preserves the president's right to assert federal control over railroads and other systems in times of war. Now, depending on how one interprets danger, it alters how the strength of these arguments. You can imagine where danger is interpreted narrowly to mean only those associated with war with a foreign nation. The argument for enhanced federal involvement for the siting of electricity generation may be limited. But where dangers are more broadly interpreted to include a range of threats to the health and happiness of the United States, a number of arguments could be seen for an enhanced federal role. The growing gap between energy supply and energy demand created concerns in Congress about national energy security, which was laid out a number of times in the legislative history regarding the tip for this backstop authority over transmission lines. Notably, even the Federal Power Act itself provides an exception to this exclusive state control over the siting of generation in times of war or a shortage of generation facilities. So I leave that to you to think about whether that, right, does that mean that that would only be in times of shortages that were the result of war, or could that be broader with any sort of shortage? Under this construction, many arguments exist, of course, as to potential dangers caused by our enduring commitment to oil, the dangers of climate disruption from the combustion of fossil fuels, which of course would have more relevance to the electricity discussion. Secondly, federal power can be evoked to further a national policy. There, in all of these other tips, there was a rising demand for wireless communications that led to a national interest to promote cell tower growth. There was a rising demand for electricity that led to this national interest to promote the creation of more transmission lines. And here, carbon-laden fossil fuels provide 88% of the nation's electricity and 79% of the nation's greenhouse gases. You can imagine a rising and growing federal interest that is causing tension with this existing federalist structure. In 2009, the Obama administration issued a call for renewable energy to supply 25% of the nation's electricity by 2025. A third point is that federal power also seemed to have been used to overcome economic efficiencies. A number of these other regimes, centralized planning was seen as a remedy to the railroads and the piecemeal development that was occurring. Similarly, you can think of transmission lines and the idea that centralized planning would be beneficial here. But there's no indication that the federal government would be any more efficient at permitting generation of electricity. And so that may be one reason for the disparity, but then you get stuck if you look at the siting of telecommunications towers. But those also just exist within one state, right? They're not talking about lines that have more tangible interstate impacts. And the fourth one is the need for congressional action to elicit federal power is minimized by alternative outlets for federal involvement. So this I was thinking because I feel like the federal agencies are much more active in addressing this national purpose than they were in these prior regimes. Developing national interest in an area that is traditionally governed by state or local control can create this tension in the proper functioning of the system. And the ability of perhaps agencies to step in and provide a release valve may be something that's minimizing the pressures to tip towards a federal role on electricity generation. Two short examples, one being that FERC has issued a number of orders recently related to renewable energy. It has used its existing authority under the Federal Power Act to provide that rates are just and reasonable to do things like in November of 2010 to remove barriers to the integration of renewable energy. And just last year, the FERC Order 1000 resulted in significant changes related to the construction of transmission lines in a way that allows for reliability and effective in consideration of renewable energy resources. The second way maybe the agencies are diffusing this tension is through the only citing of electricity generation and the only place they can do so, which is on their own federal lands. You may have heard that there have been a number of initiatives and activities by BLM lands, particularly through the Secretary of Department of Interior, and Secretary Salazar has issued a secretarial order prioritizing the development of renewable projects on public lands. By the end of 2010, the BLM had approved 9 solar projects and 25 wind projects on federal lands. So again, are these, somehow diffusing that tension and minimizing the pressures? So I just don't think that that these tensions that are existing in these siting regimes are going to go away. And so the idea was that for some of these more pragmatic factors can maybe help in the discussions to move beyond just the purely theoretical. For those resistant to tips from state to federal control, for instance, don't be overconfident that the historical dominance of the states over a traditionally local area of the law is going to be sufficient to thwart efforts to tip towards federal power. Any potential dangers to the country should be minimized, right? The states should play nice with each other to try to resolve disputes, particularly interstate disputes. We're seeing that in the transmission line area where there's a number of collaborations coming forward between the states, sort of centralizing but to a regional level instead of all the way to a federal level to try to deal with some of these issues. The state and locality should also work to streamline their permitting processes so that there won't be claims of economic inefficiencies. And there may even be some merit in allowing administrative agencies to exercise some of this creative interpretations within their existing authority to help minimize the tension. So my hope is just that these underappreciated variables can be a part of future discussion as well as the theoretical.
Questions for Professor Percival or Professor Stein, or both?
Thank you. I was wondering if you could speak more about the FERC order that you mentioned. Was it FERC order number 1000?
Mm-hmm. Yeah, there's definitely a lot of FERC initiatives, and that one specifically has to do with the transmission lines, and particularly allowing the better integration of renewables onto the grid. There's a public policy element that's required when the states are determining whether this is in the public policy of the area. And traditionally, the public policy had been interpreted to involve costs and to look at economics. And FERC specifically in the order is now including in the discussion of public policy the inclusion of renewable portfolio standards, for instance, there's a lot of little language in there that suggests, FERC is an agency that is not traditionally known for its environmental movement. Everything has kind of been tossed onto EPA for consideration of that. But you look, and much more recently, they have issued a number of, even the rhetoric is changing, that they talk about renewable energy and how we think this is part of our goal to enhance this. And so, interestingly, some of the states, of course, come out in response to FERC Order 1000, and it is like all reassertions of, just so we're clear, even with this FERC Order 1000, we still have complete control over the siting of generation, right? So, you see that this tension is not going to be going away.
I have a comment about the difference between the natural gas pipeline siting and the transmission siting. It would be interesting to respond. I think that going beyond just sort of saying political there's a real difference between the pipelines and the public reaction to them and transmission lines. And we have natural gas pipelines crisscross the United States. Most of them go from production in Louisiana to consumers in the Northeast. And there's really never been a great deal of controversy, and all the intervening states don't get much benefit from those pipelines, but nonetheless are crisscrossed by them. But if you were to try to build a transmission line carrying power, it would be entirely different. Because I've been in the industry long enough to see that transmission lines are actually beautiful with little Eiffel towers coming across them. But most people don't quite see them that way. They see them as ugly. They don't want them in their property. They don't want them in their neighbor's property. They think they destroy the views. They go through parks. They think they compromise the park. And they don't, in many cases, and particularly we're talking about renewables where you might have a new situation where there's a power source remote from the users. You're going to string those lines across the property of a lot of people that aren't going to see any benefit at all themselves from that line, and may even see their argument that their rates for power will go up as upstream power they have locally ends up going to a broader market. And so, I think that maybe there's more than just a generalized political distinction to be made drawn there, but that there really is some issues the public has with transmission lines that don't apply to the pipelines as regulated on the natural gas side.
Yeah, and I take that one step further when you then think about the generation side, right? The externalities associated with, right, with transmission lines and pipelines, right? Whether you cite one type of cell phone tower or another type of cell phone tower, they involve the same issues, right? The fear about, wireless frequencies and what that could do in terms of human health hazards, the aesthetic issues. But when you're talking about a determination between whether you're putting a coal plant in or some sort of energy efficiency, or even if you're saying coal versus natural gas, the type has much different impacts on the individuals surrounding them.
I can give an example of that is the Potomac River plant in Alexandria. And there's a plant there that in a very constrained area as far as electricity pricing goes, that is built right in this tiny area of Alexandria. It's a coal plant. But the power line supply actually goes across the river and supplies people in D.C. and Maryland. It doesn't supply Virginia. So I'm really interconnected to that part of the grid. And so for years, there was serious controversy among the neighbors who actually had to live with that power plant right next door. Not seeing any benefits in that.
Yeah. A lot of what you're describing are the issues surrounding the cost allocation problems of these projects. That, the state, because they are in control of this, needs to determine that this transmission line is going to benefit its own ratepayers. And so how do they do that if that state, for instance, is just the middleman in the transmission queue, right? The Centennial West is working quite, I think, well on a project that is going to go from New Mexico, Arizona to California. And any of you who are familiar with the famous Extension Cord project, Arizona has in the past thwarted a project where the line was just going to run through and serve California citizens. And they said, we don't want to be just your extension cord. Then what benefit do our citizens get from this? And now we have a very similar situation coming up, and Centennial West is trying to learn from that mistake and spending years to get the buy-in of all of the states and trying to make sure that there are ways to justify that there is some sort of a benefit. And what's happening on transmission line planning is it's getting bumped up to the RTO level for a number of these things. The regional transmission organizations are trying to find a way to issue cost allocation guidance so as they're trying to stabilize this and provide some uniformity in the way that you consider benefits. But it's still an open issue for many in terms of whether the benefits have to be explicit for my state or is it benefits to the region. Because of course you could argue that perhaps if you're all in the same regional transmission organization, you're enhancing the stability and reliability of the entire grid.
And not surprisingly, that Alexandria plant's going to be shut down in the next year, in part because the area around it has grown tonier and tonier.
Yeah, a couple of questions on your statements on transmission line planning and siting. And you can draw a good contrast between the electric transmission line and the gas pipelines, the petroleum pipelines, which were designed to move product over long distances, say from the Gulf to New York to New England, whereas the electric systems were designed to support small regional utilities and were interconnected only for reliability purposes, not for mass transportation of bulk power. as we move from that regime to the competitive regime, it's not surprising that we're running up against statutes that were drafted in the 1930s. What do you think accounts for the fact that the utilities, the electric utilities, were designed on this regional basis rather than, a local basis rather than a regional basis?
What do I think accounts for the reason that, I mean, I think that's a function of history and how, right, we have expanded as our entire nation has shrunk. We, of course, are finding ourselves in need of these more regional transmission lines and longer lines, but I don't think that's what you're asking.
No.
Here.
And what I'm suggesting is that the governing federal statutes were, if you take as a, if what you're suggesting is the statute should allow for long-distance transmission of bulk power. There's only one such line that's been built in this country that I'm aware of. If the statutes are at cross purposes, because the statute that you haven't mentioned is the Public Utility Holding Company Act of 1935, which required utilities to divest themselves of regional holdings and focus only on small local companies. The line I referred to a moment ago is what's known as the Pacific Intertie, which was designed and built back in the 1960s to move Canadian hydropower from British Columbia down to Southern California. So, yeah, it's easy enough to talk about the difficulties that we face now, but if we don't understand why the systems are built as they are, and why the times are now vastly different between building a massive transmission facility back in the 1960s when Lyndon Johnson was president, and what we have now, where you cannot cite even the simplest transmission upgrade. I think we're overlooking a major contributor to the issues, to the problems.
I would definitely agree with you. I mean, I guess part of my position was not that we need to be enhancing and that I'm a strong advocate for the big major transmission lines, but that there is a strong pressure for that to be occurring, both to connect renewable, and that I don't see that pressure going anywhere or minimizing itself as we continue on with the changes that are occurring in our society. And you're right that I think we hope to learn from history, and I think that's sometimes part of the tension, though, right? That these statutes were drafted at a time when things were drastically different, and now how are we supposed to adjust? And does that mean the statutes need to adjust, or can we find ways to deal with that tension through other means?
I think in the final analysis, given the way the statutes are now drafted, one of the problems I've always had with the FERC and the RTO planning and mandates is that in the final analysis, they are powerless to require what in fact they're requiring companies to do. And you mentioned the backstop authority, which we had thought would help.
They've been effectively neutered by the courts. And,
yeah,
yes.
And that didn't last long. So if you really want to accomplish what I think you're saying you want to accomplish, it's going to take a fairly significant legislative effort to do that. And one thing that will keep utilities from participating strongly in such an effort is the perception, which is indeed true, that if such a piece of legislation is passed, it's going to divest the states of a major part of their jurisdiction. And the utility, 85% of whose financial future is in the hands of the state, is not going to want to be out in front of that kind of argument.
Right. And they don't want their whole livelihood to depend on the feds either. They often think.
Yeah, but you made a very good point about the justification for facilities, because in the areas the places I'm familiar with, if we wanted a transmission upgrade, we had to put company officers on the stand under oath to testify that these upgrades were necessary to serve the customers of the specific utility, not to move power from Georgia to Connecticut. And that's another major issue. I'm sorry.
No, thanks. I would love to speak with you afterwards.
Let's move on.
I have one question for
Sure.
Mr. Percival.
You mentioned the possibility that if Congress were to adopt a statute that barred EPA from addressing greenhouse gas emissions, that would lead to a revival of federal common law nuisance liability. Is there an alternative possibility? Is it possible that a court would, obviously much would depend upon how the statute is worded, that a court, the Supreme Court, would interpret the adoption of legislation barring EPA from regulating greenhouse gas emissions as a statement by Congress that it didn't want anybody regulating?
Well, if Congress said that it also wanted to preempt the federal common law, then it would do that. And I think that, the real sleeper here is that American Electric Power expressly reserved the question of whether the state common law is preempted by the Clean Air Act. And it's probably not under the logic of that, but given that you're dealing with a global problem, the idea that you apply the law of the source state seems like kind of a weird response to it. But it's possible that states could start bringing common law nuisance actions under state common law to address greenhouse gas emissions, and then that issue would be really teed up. But it probably isn't preempted under existing law. Congress could do so if it wants to, but in doing so, the people who are very big on states' rights in the Congress would have to say we're going to take away one of those rights by, in fact, preempting it.
Yes.
Yeah, I have a question about nuisance law. I apologize, I'm slowing down the moon here. Now, I guess what may be an oversimple understanding is that basically you have property owner A and B. A is doing something on its property that is to A's benefit, but not necessarily B's, but that the smells, the fumes, the cost, or transfer to B. Is that, I hear these discussion of, particularly as you want to apply it to greenhouse gases, but also at the TVA case in North Carolina. How does nuisance law account for the possibility that the activity on A's property is benefiting B?
Well, you're talking about private nuisance law there. Most cases I was talking about were public nuisance law, which would actually have very different historical roots. But the general standard is substantial and unreasonable invasion of a right. And so courts can certainly balance the equities in determining whether or not to declare it a nuisance in cases like that, where the argument is this is very useful activity. If you look at the history of the common law litigation, the courts did not use a real heavy hand. Even when they issued those injunctions, they made sure that the injunction wasn't so stringent it was going to shut down the activity, because those smelters were enormously beneficial to the local economy at the time. But they kind of used the fact that they had this equitable authority as a way of encouraging the development of better pollution control technology, so that in the long run that threat of much more stringent intervention succeeded in improving technology in a way that helped relieve some of the conflict.
And if you add that to the case of greenhouse gas, right? I mean, you think about the nuisance there. It's primarily a theory that it's going to change, at some point, change the climate of the Earth in a way that would be unfavorable to everybody on it.
Yeah, well, the classic case there is the Kivalina case that's currently before the Ninth Circuit, where an Alaskan village is arguing that it's going to have to be totally relocated because of sea level rise caused by greenhouse gas emissions. And they're asking for $400 million to help them rebuild the village on higher ground. I think those cases will fail the proximate causation test, but the lower court there said it was a political question. Now, the AEP decision, the justices split 4-4, because Sotomayor was out of the case because she had initially been on the panel in the Second Circuit. But I think it's fairly clear from AEP that it's not a political question, that you do have standing. So you'll get your day in court. Ultimately, I think, with greenhouse gases, the causation is so attenuated that you'll lose on that point.
Okay, if there are more questions for Professor Percival or Professor Stein, let's hold them till our end questions and move forward right now with Professor Glicksman.
Good morning. I want to add my thanks to Professor Fraley and to the Journal for inviting us to participate in what's already been a highly informative conference. I want to talk to you about government reorganization. And part of what I want to talk about involves federalism considerations, but what I want to argue is that the federalism concerns that will be triggered by and that will push policymakers in different directions when government reorganization is called for is only part of the picture, in that we ought to be trying to put these federalism concerns into a broader context. So government reorganization is a frequent occurrence, and there are many examples of it. Some of them are reflective of broader dissatisfactions with the role of government in our society. Just this week there were some hearings in Congress in which the majority party in the House sought to solicit ideas about how to reduce the obesity of the federal government by putting it on a diet, I guess. But quite often the reorganization initiatives are spurred by more discrete events, and there are some recent examples that come to mind. The Department of Homeland Security was created in direct response to the events of 9/11. That involved a massive reorganization of a variety of government agencies involved in intelligence gathering and other national security concerns. The Deepwater Horizon explosion a year and a half ago or so spurred the Interior Department to eliminate the Minerals Management Service and to create a new set of agencies to deal with the development of and regulation of offshore oil and gas development. Most recently, the President, just a couple of weeks ago, proposed to abolish the Department of Commerce and to consolidate a number of different agencies with jurisdiction over small business and trade, a proposal that's been met with, I think, hostile reaction from both parties thus far. So government reorganization tends to be controversial, and I'm going to use my example of climate change adaptation as a reorganization effort that I think is already underway but is likely to accelerate. So my talk will discuss how the government's authority to deal with climate change, and in particular to adapt to climate change, is going to spur the need for reorganization of government at all levels. And my goal in talking to you today is to provide some tools for assessing whether realignment of agency functions might be beneficial, and if so, how we ought to proceed if and when any realignment of authority occurs. The presentation is based on a paper that I'm currently in the process of writing with Professor Alex Camacho, who teaches at the University of California, Irvine. And ultimately, we hope our analysis will be useful in environmental contexts other than climate change adaptation, as well as in non-environmental contexts as well. So what I want to do is briefly describe why I think the need to adapt to climate change is going to create pressure for rethinking how government authorities are organized. Talk a little bit about the values that are often implicated in reallocation of government authority. Introduce a taxonomy of reorganization along a variety of government dimensions, which aren't always recognized or discussed as separate dimensions, but that, if discussed as separate dimensions, may sharpen our ability to compare different organizational structures as the dimensions may cut in different directions. And then, if I've got any time at the end, briefly I want to talk about one of the case studies we plan to use to illustrate the utility, hopefully, of our taxonomy, and that is the impact of climate change on coastal resources. So why do we get government realignments of the sorts I talked about a minute ago? Well, we get reorganizations of government authority when political energy is mustered to move in that direction. And that political energy may occur as a result of dramatic events, that revealed the inadequacies of existing government structures: 9/11, Hurricane Katrina, Deepwater Horizon, the 2008 financial crisis. I think were all dramatic events that led to some dissatisfaction with the way that government authority was currently organized. Sometimes the organization occurs as a result of changed circumstances that render the assumptions on which existing regulatory programs and structures were created obsolete. And sometimes simply we gather experience over time that what we thought would work has not worked, and that we need to change even if our fundamental assumptions about the nature of the problems hasn't changed. Well, I think climate change is going to reflect at least some of these triggers. I don't think it's going to be a single dramatic event that's going to convince people that we need to change the way government is equipped to deal with climate change. It's hard to trace climate change as the main factor for any single event. There were some people who thought that Hurricane Katrina would be an eye-opener and convince people that climate change was real, was happening, and was having significant adverse effects, but I don't think there was a single scientist who was willing to step forward and say that climate change was responsible for making Katrina as virulent a storm as it was. On the other hand, I did hear Jim Hansen a week or two ago, a NASA scientist, attribute the droughts and heat waves in Texas to climate change. But I think more likely it's going to be long-term patterns or trends that are going to drive the reorganization that I think will be needed to allow the government to effectively adapt to climate change. Climate change is already causing and will continue to cause unprecedented physical and environmental changes, both in the U.S. and around the world. And those physical changes are going to disrupt existing economic and social relationships in ways that will create regulatory stress, as government programs are called upon to deal with problems that were never imagined when the programs were created, and the programs as a result simply weren't designed to deal with. Those stresses are going to be especially problematic if the existing programs and institutions are built on assumptions that are no longer valid as a result of climate change, or that seek to achieve goals that are no longer realistic or have become completely impossible as a result of climate change. Just to give you an example that's not federalism related, there's a national park in California called Joshua Tree, and there's some people who think that climate change will lead to the extinction of Joshua trees in that park. So how do we have a Joshua Tree National Park if there are no Joshua trees there anymore? We need to at least rethink the name of the park, if not the way that we manage its resources. So I think that climate change is likely at some point to create significant political energy for realignment. And some of that's already occurring. The President created a couple of years ago an institution called the Interagency Climate Change Adaptation Task Force, which is led by a combination of EPA, NOAA, and the Office of Science and Technology Policy that's trying to coordinate to some degree how the federal government and its components deal with climate change. So what are some examples of the kind of physical changes that are going to create regulatory stresses? Well, if we're dealing with coastal resource management, warming ocean temperatures and melting ice sheets are going to lead to rising sea levels, which is going to cause more frequent coastal flooding, which is going to create a need to accommodate, among other things, the movement of displaced peoples, and may cause us to need to restructure impaired transportation and energy infrastructure that are adversely affected by flooding. Rising sea levels are also going to increase saltwater intrusion into estuaries and aquifers, and traditional solutions to saltwater intrusion, which have involved storing freshwater resources that can then be called upon later on, may no longer work if the areas affected by intrusion are also affected by severe drought. Public health is another area in which climate change is going to create changes that put stresses on existing regulatory structures. Rising heat is going to worsen levels of ozone pollution. This is going to create greater difficulty for the states to meet the national and air quality standards for ozone under the Clean Air Act, and may trigger the need for more EPA intervention in the creation of federal implementation plans that displace state plans. Extreme weather events like Hurricane Katrina may disrupt the flow of medical supplies and create shortages of hospital space that will create the need for greater regional or national coordination to respond to those kinds of events. The appearance of new viruses or other infectious diseases may create a need for greater national coordination and maybe even quarantines or restrictions in interstate movement that we haven't seen much of in the past. So what kind of values are going to be implicated when we decide that government reorganization to deal with problems like climate change are necessary? What should we be thinking about in terms of yardsticks by which to assess the merits and demerits of different possible reorganizations? Well, I think there are at least 4 that are going to be in play. First of all, and most obviously, effectiveness. Will in particular government reorganization successfully address the problem that we're trying to deal with better than existing structures do? So if we're concerned that existing institutions are not well equipped to deal with public health problems that result from climate change, will a reorganization that moves the locus of authority in one direction or another put us in a better position to minimize the adverse effects on public health of climate change? If the answer is no, you have to wonder whether or not the reorganization is even worth thinking about. But there are at least 3 other values that I think are likely to be trenchant. One is efficiency, and we need to think here both about the impact of reorganization on administrative costs and on compliance costs. In terms of administrative costs, what we don't want to see is having multiple levels of government performing the same tasks. That's inefficient. If one agency can perform a task effectively, you lose opportunity costs if you have 2, 3, 4, 5 agencies doing the same task. Compliance costs involve things like requiring regulated entities to comply with multiple levels of regulation. Equity is another goal or yardstick or value that I think we need to think about. We need to consider whether proposed realignments of government authority are fair, and we can assess equity along a variety of lines, including vertical equity, rich versus poor, horizontal equity. We want to make sure that people that are similarly situated are treated alike. Geographic, we want to probably avoid excessive concentrations of risk. And there's temporal equity that's at issue as well. Intergenerational equity, we don't want to take steps, perhaps, that create significant problems for our successors. And finally, I think we need to think about accountability as a yardstick for assessing government reorganization. And this is a multifaceted value, I think. It involves, at a minimum, things like transparency, open processes for making decisions. We need to think about opportunities for public participation in decision-making processes by government. We want to make sure that decision makers are perceived as unbiased. We want to build in protections against capture of regulated agencies. And we want to promote adherence to rule of law values. All of those, I think, are relevant to whether or not the public perceives a decision-making structure as one that's accountable and legitimate. So in terms of our taxonomy, what we're going to be arguing is that when we think about government reorganization, we need to think about more than just federal versus state, or federal versus state versus local. One of the things we want to place greater attention on is the difference between what we're calling substantive and functional jurisdiction. So when you're designing a government program, you can design it along at least 2 different kinds of rubrics. So if we want to deal with pollution, for example, one way to deal with pollution would be to create an environmental protection agency or an analogous state agency that establishes different offices to deal with air pollution, water pollution, and solid waste. And then within each of those offices, you could have the air pollution people performing standard-setting functions, permitting functions, and enforcement functions. And the same for water pollution, and the same for solid waste disposal. But you could, right off the bat, design it in a completely different way and say we're going to have 3 different offices within EPA, one of which is responsible for standard setting. And the standard setting office will deal with air pollution, water pollution, and solid waste disposal. You could have a second office dealing with permitting, again, covering both sources of air pollution, water pollution, and solid waste. And then you could have a third office to deal with enforcement issues, again, across environmental medium lines. Now, EPA actually is an amalgam of both of those. It doesn't fall either within the green or the yellow egg. It's a little bit of both, but I think when we embark upon possible reorganization efforts, I think we ought to think about whether it makes more sense to divide jurisdiction on substantive lines, air pollution, water pollution, solid waste, or instead along functional lines. The other 3 dimensions are ones that have been discussed by academics and policymakers, sometimes not in exactly the manner in which I'm going to talk about them. Each of these dimensions has different poles that have benefits and disadvantages, and Professor Stein's already talked about some of them. Professor Busby will talk about them as well. The analysis tends to be context specific. Let me, as a general matter, see if I can talk about the dimensions. So, one possible dimension is centralization versus decentralization. Obviously, this is a federalism question, at least in part. And what I want to indicate with respect to each of these dimensions is that we're dealing with a spectrum of possibilities, rather than a binary choice. So on the left end of the spectrum, we could have an extremely centralized regime that reflects a decision on the part of the federal government to completely preempt state or local participation. There's one agency, it's a federal agency, and nobody else has any say in the way a particular problem is dealt with. A slightly less centralized regime would be one in which, again, state and local authority is displaced, but we have 2 federal agencies instead of 1 to deal with the problem. And then on the right side of the spectrum, you have a decentralized regime, which reflects the cooperative federalism model that Mr. Martella talked about earlier, where you have a variety of federal and state agencies, all of which are authorized to deal with different aspects of the same problem. So when we're thinking about where to place our reallocation along that spectrum of centralization and decentralization, we want to think about the values that I talked about a minute ago. And depending upon whom you talk to, you get different analyses of whether the values are best promoted by a centralized or decentralized regime. So decentralization, for example, can promote effectiveness by leveraging local knowledge and expertise and by fostering the kind of regulatory experimentation that Professor Stein talked about. It can also promote accessibility and therefore accountability, because interested persons typically have an easier time accessing and participating in local government decisions than federal decisions. But centralization can have its own benefits, which could include efficiency. That is, you can take advantage of economies of scale if you operate a government system on a centralized basis. It can also promote effectiveness by overcoming some of the kinds of collective action problems that Professor Stein talked about, interstate externalities and the race to the bottom. The next dimension that I want to talk about is one that we're calling distinct versus overlapping authority. And again, we're dealing with a spectrum here rather than a stark dichotomy between 2 different choices. But here's my example of a regime that's distinct versus one that's overlapping. And so the federal government owns a lot of lands and resources which it's responsible for managing. It's created a system of national parks that are managed by the National Park Service. A separate system of national forests managed by the National Forest System, and a third system of wildlife refuges managed by the Fish and Wildlife Service. And the Park Service has no authority over the forest, and the Forest Service has no authority over the parks, by and large. But we deal with wildlife management in a slightly different way. The federal land management agencies are responsible for managing wildlife within their own jurisdictions. So the Park Service regulates activities that deal with wildlife in the parks and the Forest Service and the Fish and Wildlife Service, respectively, in their own jurisdictions. But all of those agencies defer, to some extent at least, to state fish and game agencies in terms of managing hunting and fishing on federal land systems. We also have 2 other federal statutes that give authority to address wildlife management to other federal agencies. The Council on Environmental Quality is responsible under NEPA for overseeing the preparation of environmental impact statements by agencies like the Forest Service when they want to authorize timber sales that might adversely affect wildlife species. Similarly, the Endangered Species Act requires that agencies like the Park Service, the Forest Service, and the Fish and Wildlife Service consult with either the National Marine Fisheries Service or the Fish and Wildlife Service if the activities proposed by those agencies might result in jeopardy to endangered or threatened species or adverse modification of their critical habitat. So all those agencies have some say in what activities take place on federal lands that might affect wildlife, and there's overlapping jurisdiction among them. So what are the benefits of creating a distinct regime like the one on the left side? Well, it can create efficiency by avoiding duplication of effort. It can avoid the need for costly coordination among the different regulators. It can minimize uncertainty among regulated entities about what the responsibilities are because they only have one agency to worry about. But overlap can create benefits as well. It can create effectiveness, for example, by creating redundancy that reduces the risks of regulatory gaps. These are the kind of backstops that a couple of the speakers have talked about earlier today. Overlap can also allow for diversity of approaches and opportunities for learning and innovation that can then be passed along to other regulators. And the final dimension I want to talk about is one that we're calling independence versus coordination. Here we're assuming that there is at least 2 regulators, if not more, either in a substantive or functional jurisdiction area. And on the left side, we have the agencies that are authorized to act in an area operating independently of one another. And on the right, we have coordination. Coordination can occur along a spectrum of possibilities that range from simply requiring one agency to notify other agencies with jurisdiction about what it plans to do. You could add to that the other agencies have an opportunity to comment on what the first one plans to do. You can require that the first agency respond to the comments of the other agencies. You can allow all agencies to participate in deliberations on how the first agency is going to go about its task. You could create a system in which each agency has a vote on what the first agency does. It could range from a majority vote to a supermajority vote. And then finally, you could have a system in which unanimity is required, so that each agency with jurisdiction has the authority to veto the actions of others. Now, coordination has possible benefits that include increased effectiveness by promoting exchange of ideas among multiple regulators, increased accountability by reducing the risk of capture because you have multiple agencies that need to be captured and not just one. But independence has its benefits as well, at least potentially. It can increase efficiency by avoiding the need for coordination among multiple regulators. It can increase effectiveness by preventing what some people refer to as groupthink. If everybody's coordinating, they all tend to see the problem the same way and to think about the same solutions. If they're acting independently, you've got a better chance that somebody's going to come up with a completely novel idea that nobody else thought about. So what you wind up with is the possibility of combining these different dimensions when you're reallocating government authority in a bunch of different ways, and these are just several examples of how the various dimensions can operate in relation to each other. And then again, to bring the first point back in, you can imagine creating different structures depending upon what function you're dealing with. So you could have a centralized system of authority if you're dealing with information gathering and distribution. You could have an overlapping but independent structure if you're dealing with the establishment of standards. So both the federal government and the states have the authority to set standards. You could have overlapping and coordinated authority if you're dealing with enforcement. So under the pollution statutes, for example, in some circumstances, state action precludes federal action from occurring. So there's overlap, but there's some degree of coordination. So one way to look at the way these various dimensions overlap and interrelate with one another is to say that if you've got a fully centralized regime, only one agency with all authority, you don't need to think about the other dimensions. But anything other than that, any sort of decentralization, I think gives rise to the possibility of creating a distinct or an overlapping regime, and whether you move toward distinct or overlapping, you should think about whether or not the system should be coordinated or independent. So I'm going to skip most of the case study for purposes of time and just talk about what we think most generally is likely to be a good way to think about these alignments along the various dimensions. I think it's likely that in the context of climate change adaptation at least, it's likely to be a good idea to centralize functions like information gathering and financing. It doesn't make any sense to have multiple agencies all researching the same scientific question. One agency can do the research and disseminate the results to the others. It's likely that when we're dealing with a problem as enormous as climate change, the federal government is going to be in the best position to have the resources needed to do effective research. And so, again, I think the federal government ought to take the lead in financing research efforts. You're probably going to want to have some degree of centralization in planning to deal with things like outbreaks of infectious disease that could cross state lines. You're probably going to want to have less centralization when we deal with implementation. These implementations are going to depend upon knowledge of diverse local conditions, so that local authorities are going to be better situated to deal with exactly how to implement whatever regulated program you come up with. In terms of overlap, I think there are areas in which less overlap is going to be called for. There's no reason I can think of to continue to have two federal agencies, for example, regulating coastal wetland development, EPA and the Corps of Engineers. We probably ought to eliminate the overlap and give one agency or the other the authority to deal with those problems. But you probably want to retain overlap in areas like adoption of standards. You may want to allow states to continue to be able to adopt standards that are more stringent than those adopted by the federal government. For one thing, state standard setting as a supplement creates a safety net that might be a good idea to protect against the uncertainty and unforeseeability of the effects of climate change. Finally, in terms of coordination, some of this again is already taking place through the activities of the Interagency Climate Change Task Force. But we might want to enhance the degree of coordination by changing statutes like the Coastal Zone Management Act, which currently is more decentralized and less coordinated than some of the other federal environmental statutes. It might be a good idea, for example, to require all states with coastal areas to submit plans to the federal government on how to deal with coastal resources. At present, they don't have to do that. On the other hand, you probably don't want to move to a completely coordinated regime because some independent thinking is probably a good idea to promote the ability of agencies to avoid groupthink and to create solutions for unique problems for which a one-size-fits-all solution is probably not going to do the job.
Professor Busby.
Greetings, everyone. I can't believe you all sat there so long, but if any of you are awake, it's nice to see you here. If anyone's asleep, nudge them. So first, I'd like to say thanks to the organizers. Did a great job in getting all of us here, the panelists as well, especially for Professor Fraley for being such a wonderful host. Actually, a lot of the kind of basic background I was going to talk about has been covered, so what I'm going to do is the extent you're looking at my outline, is cover some of the first page very quickly, and then jump to discussing climate change, mitigation, federalism issues, and design, and talk through some of the issues I think have been perhaps underanalyzed. First, let me start off by saying, generally thinking about environmental federalism, most people immediately think about vertical issues, federal, state. And the first thing I'd say about that is if you actually look at the federalism gains of the last 20 years, what you actually have much more is inter-branch conflict, where federalism is the area, the source of conflict. And for you environmental law students, practitioners, and the like, the norm actually is that Congress in its laws creates and embraces schemes that have substantial overlap. They are, as Professor Percival talked about, you have delegated program federalism, you have some preemption, but it's actually quite rare that you have outright preemption. What you have is floor preemption, where federal schemes basically prevent states from competing and racing to the bottom, but still allow states to do much more. You have savings clauses, so what you really have is a federal floor and substantial latitude for states to do more. And that has been the norm. And so what you end up having is federal law that creates these bottoms or floor, then you have the states able to come in and do additional action, and plus you have common law, state common law, which is preserved, and as talked about under the Willett case, the Supreme Court quite emphatically, in that case at least, emphasized that state common law remains even if federal common law has been preempted by federal statutes. So that's the legislative choice, but when you start looking at what's actually happened within the executive branch and the federal courts, what you've seen over the last 10 to 15 years is, in many instances, an executive branch that has been hostile to the kind of choice of overlap and interaction, and through an array of regulatory measures and positions in Supreme Court cases, you've had an executive branch that has sometimes sought to eliminate or reduce that federal choice to have overlap and intertwined authority. Similarly, the courts, if you look at a number of the cases that were referred to in several of these presentations, and Mr. Martella alluded to very lightly, what you actually have in a number of the big federalism environmental cases in the courts, the DC Circuit and the Supreme Court, you've had courts that, regardless of the legislative choice, will sometimes hearken to federalism values, supposed federalism values, but actually interest in uniformity and unity and more rule of law values, and largely a failure to consider the values reflected in legislation, which is embrace of overlap, intertwining, and basically a lot of law that provides a fair bit of protection. In addition, something that's an interesting twist I just started looking at, if you look at a lot of the federalism cases, especially for the Supreme Court, there's an increasing tendency in these cases to engage what I call in quasi-history or quasi-factual claims about the world and the way the law has worked, which are kind of an interesting puzzle jurisprudentially, because the court will talk about an area as being an area that, say, has long been state turf, in ways that actually are empirically wrong. And so there's a question how much we as professors and you all as lawyers-to-be and lawyers and practitioners, or working policy arenas, might be able to go back to policymakers and show empirical error in some of these claims about how the law has worked and who's occupied certain turf over times. And it's just kind of an interesting twist here. So if you look at a lot of the big cases, including the Swank case, which along with Orpanos are the big cases about the reach of federal jurisdiction over waters, and I guess waters at the limits of federal power over waters. The court has made, or several justices have made, claims about the nature of who occupies which areas, which are eminently contestable. They're really categorical claims cloaked as factual claims and are usually wrong. So in any event, so what I want to turn to now is, so you have a lot of interbranch conflict, and what I want to turn to, because I think it's maybe the most important question that will come up in the coming years, is thinking about climate legislation. That is, if the federal government ever gets around to the business of enacting a law, a comprehensive law to address climate change and climate mitigation, what would be the appropriate federalism answer? And And so first, for those who are not thoroughly immersed in the world of climate, the policymakers tend to break apart adaptation, which is, okay, climate change effects are happening. How do we respond to the changes that are already afoot? That's the adaptation prong that Professor Glicksman talked about. And then you have the issue of mitigation, which is, okay, how do we mitigate, how do we reduce the sorts of pollution that are contributing to climate change? And so I'm going to focus primarily on the climate mitigation question. And so basically, the initial response of the first people who studied climate had basically the following argument, which is that climate change is a quintessentially global phenomenon, that it is as large as you can have. It is a global problem, and therefore we need a global solution or second best national solution. And the view therefore was, so we should have a federal law that really takes care of the problem. But what we actually had for quite a while, until Massachusetts versus EPA, was federal inaction and states stepping into the picture. Local governments as well, enacting an array of things from renewable portfolio standards to coming up with their own state-based and regional cap-and-trade schemes, and a number of other initiatives, a lot coming out of California that were then mimicked in other states. And so a question then is, which scholars have been focused on and ended up being part of the federal debates in 2009 and 10 is, does this make sense? In other words, is this state activity kind of a bothersome little gnat that we should swat away or squish? Or is this something that actually makes sense and should be embraced as an ongoing part of any federal climate legislation? And so that's what I want to focus on. And my perhaps counterintuitive conclusion is that actually, if you want climate legislation to succeed, to actually achieve goals, to be stable and foster innovation both on the government side and private side, retaining state and local roles could be a critical way to actually achieve federal goals. Let me step back first, one caveat. So I'm going to be talking about why we might want to retain state and local roles. This is not to say we don't need a comprehensive federal climate law. Okay, just to be clear, everyone, I think, who studies the area and believes that the science is, which is quite overwhelming, is accurate, believes that a federal law is necessary. So I'm going to take as a given that we need a federal law that would do most of the work, that you would need to have a federal cap-and-trade scheme, or perhaps maybe a more primitive structure, maybe a limited industry, largest polluter, best available technology kind of mandate, but something that would get substantial ramping down of greenhouse gas emissions. So I'm going to take that as a given that that's part of what the picture needs to be. And the question is, if you have a federal scheme, what would the state and local role be? And my counterintuitive answer is that we need to have a substantial preserved state and local role. And let me, I guess I have about 7 minutes or something, is that right? I mean, you guys have all been sitting here, you're like, let me up. But let me actually just start, before I launch into the rationale, just recount briefly an interesting meeting that I was part of in Washington while the federal bills were being kicked around. But before the main bills had been floated, there was a meeting set up between a bunch of state officials who worked on various climate and renewable portfolio standards, renewable energy efforts, so that the top kind of air officials from most of the major states have been active in this area, and then some of the legislative counsel to the key committees in the House and the Senate who were in the midst of drafting bills. And the subject was explicitly, was there a need to preserve state roles? And early floated language was basically appeared to be ready to throw state and local actors away and say there was no need for them, we'll have the perfect federal solution. And it wasn't clear, frankly, that the environmental groups cared either, that I think they were largely comfortable with this idea that you'd have a federal solution, and part of it was pragmatic. This might have been the price to get industry buy-in, was to get a really federal scheme and substantially eliminate the state and local role. So this meeting was set up, people came in, and several of the federal counsel, and many of whom had been at top environmental groups and law firms, very quickly kind of explained why, of course, the answer was federal. and then started describing the scheme they were going to devise. And slowly hands started coming up, and some people from California said, well, you realize that we tried that in California, and that particular structure didn't work at all for the following 4 reasons. And then they kept talking, and then another hand would go up, someone from Massachusetts said, you know, you realize that you have this problem because you have the revenue stream, you have this structure and the incentives, and it kept happening until finally the so-called federal leaders basically shut up, and the state people started explaining how they had structured their cap and trade and regional schemes and then problems they had and why it was important and effective. So it was an interesting example of a kind of state teaching the federal legislators, and I don't think coincidentally, when the bills came out and started being floated about 6 weeks later, they had new provisions that substantially preserved state roles. And so the leading bill's choice was to have a knock the states out of cap and trade for 6 years, so it would be exclusively a federal cap and trade scheme, but otherwise allow the states to do anything else that they wanted, provided it was not part of a cap and trade scheme. So I'm going to explain why that made sense, and I'll sit down and answer questions. So the short answer is that the only way to think about this is to think about failure. And I know we don't, you know, it's really kind of a downer of a way to think about it, but if you think about climate change, it is, as Rob has written about and others have written about, it is probably the most challenging regulatory puzzle imaginable. And any climate change bill is going to require really amazing scientific judgment, policy judgments, standard setting, figuring out the appropriate cap, hundreds of implementation decisions, if not thousands, that would work their way down for years, and the need to create really stable markets in which private actors will invest in technology and other sorts of innovations that will basically create the means to reduce greenhouse gas emissions. And so if you assume perfect federal law and perfect implementation, you perhaps could have a completely federal scheme. But if you look at the history of any body of law, especially environmental law, what you find is basically substantial failures. Things don't happen on time and things are not nailed down exactly right initially. And if you went to a completely federal scheme, that is, if you had federal scheme knocked out the turf of state and local government, you would have one big problem, which I think is the biggest problem people need to think about. If you knock out state and local governments and the federal government just sets the standard wrong, there is nobody else who can act. Okay, just to be clear. So there is no latitude for other actors to step in if they're completely preempted, because it would be an express preemption provision, and there wouldn't be that ability even to step in and try to do something. Okay. Second, relatedly, you could have the other issue, which is what happened in 2010 and 2011. What happened in 2010 and 11 is the climate bills weren't passed, and then the efforts were afoot, as just discussed, for Congress to knock out the power of EPA to act under the Clean Air Act. And the same thing, of course, could happen if there were a completely federalized climate bill. The ability of Congress to then pass a single law targeted knockout punch to eliminate any regulation of greenhouse gases would be made far easier. Okay? And so it's important to realize that that is a distinct possibility. And if the status quo were, or the baseline condition were, states have no authority, then the entire game in town would be to either knock out the federal law if you were industry that disliked it, or alternatively, it would be a move at the regulatory level to derail the implementation steps and prevent things from happening. However, if the states retain their authority, it changes the dynamics, because then states will have this potential to act, and it changes the incentives of all actors to realize that if the federal game is derailed or is ineffective, and the states start stepping back into the picture, then you do start having this sort of patchwork of regulations that industry tends to dislike. And so you change the incentives of the major polluters to do what they can do to make sure the federal scheme becomes real. And so again, would the states play a huge role? Most states actually explicitly have said, we really don't want to play much of a role. Okay? Should they retain that ability to act, that's what's important. and if they can step in here and there, it will make a difference. Now, I have a number of other points thinking about regulatory failure, but let me just close my thoughts with time for questions, and people can get up and walk around. There's one additional point which I think has been underanalyzed, but is important. And this actually came to me from talking to people who were in energy business, especially renewable energy sort of businesses, and that is what they've been most terrified about is the elimination of the legal infrastructure that has driven their markets. Okay? Now, some of it has been through tax incentives that make certain renewable energy schemes quite tax favored. Stimulus money similarly has done that. But also, at the state level, a number of more aggressive efforts to eliminate pollution and address greenhouse gases has created markets for innovative means to achieve these goals. And so the biggest concern for these people is that suddenly there would be an abrupt destruction of that web of laws. And so you might think the answer would be, well, let's have a federal law. But you have to realize that if there was an exclusively federal law, that would be, any market would be discounted based on the risk that the federal law would be abruptly shelved, okay? Or an implementation would be derailed. If instead you had federal law, state and local, that could be acting and might continue acting in sort of either unorganized or organized sorts of ways and creating similar sorts of energy improvements through regulation and incentives, well then what you have is state markets and federal markets which create basically a much more substantial web. And part of the game in the climate legislation battles was a lot of people who were going to Washington and talking to others who were influential in these battles were people who wanted to make sure, for example, that California, which by itself is a huge market, would not suddenly lose its capacity to continue implementing and innovating on the energy and environmental front. And I think this is critically important, that basically it's important to see, even if you have a diversity of laws, if they're all addressed at reducing greenhouse gases and improving energy efficiency, what you have actually, despite the disparate nature of the law, is you may have a quite resilient and substantial fabric which will be an underpinning of markets. And it's important to keep that in mind. So I'll stop there and allow people to ask questions. So thank you very much.
What happens if we don't get federal legislation?
Get lifeboats. No, no, I mean, the short answer is what's actually starting to happen that was interesting, which is you have, first, states have continued acting, and so, states have acted on their own, and you have some regional compacts that are working, and so part of it is you can have a sort of gradual increasing state role, which has several benefits. One is, if you're familiar with all this behavioral economics or cognitive psychology, there's a strong status quo bias where people are attached to what they have, but they also become less uncomfortable with the new when they see it's working and the world doesn't come to an end. And so if you actually look at American populations, if all of the state actions and regional compacts kind of continue to come online and act, what you'll actually have is a majority of United States citizens will be living under a variant of a cap and trade scheme. And if they realize that in the end the world doesn't end, that may change somewhat federal politics, as may, frankly, very salient storm conditions or another Katrina or something which may make people, or very warm winters where no snow falls anywhere, may change people's perceptions. That could change the politics. But I think part of the game is allowing this kind of experimentation and trying things out. Also, I'd add that with everyone's probably followed how much solar has dropped in cost. And so one of the things that happened with all of the state efforts and efforts abroad in Europe especially, with increasing solar arrays, the price has dropped. And so things that seemed absolutely impossible, now people realize on a cost basis may be rational for some areas, even without substantial subsidies. So I think it may change the game over time. That is, the nature of politics and resistance may lessen. but there still is a need for a national bill. I mean, it's just hard to get around it there. I'm from the state of Georgia, where there is, where as a professor, it's always, I'm actually from New York originally, but teach in Georgia, but you can almost always say, look at these advanced states, and then look at Georgia, because you have in Georgia very strong laws that shut down any efforts to have renewable energy efforts. I mean, it's actually law called the Territorial Act, which has quite a pernicious effect. So while it's good to have the states, you also need a federal law which would deal with states that are really defeating some of these purposes.
Just to support that at the global level, there's a really interesting controversy going on now. The EU has declared that all airlines flying to and from the EU have to be part of the EU cap and trade system. And that has all the non-EU countries outraged, but they can be exempted from it if they regulate their own airlines' greenhouse gas emissions. So it looks like what's going to happen is the International Civil Aviation Organization, which in 2004 rejected any notion of a global deal to control airlines, is going to get together with the EU and try to negotiate that. So if you have a fairly successful system that's upheld in a fairly large player, it may end up, bootstrapping itself into a much larger system.
An example of the kind of potential for state and local effective action that Bill talked about is the proliferation of renewable portfolio steering, which again, Bill referred to. These are laws that states have adopted that require that every utility produce at least a minimum percentage of its power through alternative fuels that do not generate greenhouse gas emissions. And last count, I think at least 30 states had some form of renewable portfolio standard in effect. And there was talk at some point of adopting a federal portfolio standard, and if that had happened, it might have displaced the state regimes, but there was opposition to that. It didn't happen. In the meantime, the states continue to implement their standards. I think California's is among the most stringent. 33% of the power generated by electric utilities, I think by the year 2020, has to be from renewable sources that don't generate greenhouse gas emissions.
Sam, you have a question?
I just wanted to make a note if there are other questions too. We should continue, but I wanted to make a comment, and if you have a response to it, regarding the panels this afternoon. You've all described, responding to questions of federalism between the branches of the federal government, between the federal government and the states, much of it in the context of traditional environmental laws, so Clean Air Act and Water Act and so on. There is another system of economic regulation that takes place at the state level that seems to be, that will have a role in implementing any federal climate legislation, but that is already making decisions about compliance with Clean Air Act, about investment decisions, that is sort of affecting climate-related planning processes for utilities. And I don't know, the panel this afternoon will sort of flesh out what's happening in that space, and I don't know if you have thoughts about, and if other people have questions, you should go ahead and ask them too, but I hope that folks will bear in mind that that system of economic regulation operates in parallel and in response to the federalist system for cooperative federalism under the Clean Air Act and Clean Water Act. And yeah.
I'd say one thing, going to the first part of your question and comment is one thing that people neglect, and this is not my idea, but that when you have states that are acting in an area, both energy, say, and environment, one substantial benefit of their acting is literally just the reality that they're working and regulating in an arena. Ann Carlson is a professor at UCLA, has written some very nice work on environmental federalism. She has a paper she's working on now where she's realizing that one of the interesting parts of all these stories has been California's role, and part of it is that California has basically substantial regulatory expertise and capacity. That people maybe neglected the fact that states aren't just states, but states over time build up expertise and regulatory competence, which allows them both internally to be effective and also be teachers of other jurisdictions. And that you need, when you're thinking about structures, it's pretty important under any, like if you're looking at business, literature on business and total quality management, whatever, any area, it's good to have many centers of expertise. You never want to put all of your eggs in one basket. And so her view, which I think is sound, is that states that build up regulatory competence can perform very valuable functions. And so kind of combining Rob's last point about the nature of renewable portfolio standards and states that have been juggling energy and environment, those states that have been quite active really do build up expertise and provide important lessons.
But I'll just add, don't forget, what do we do about those 20 states that don't have any renewable portfolio standards, which is why this all gets connected. Professor.
Yeah. Going back to the backwardness of certain regions that you mentioned, as opposed to, say, the advanced thinking and activism in California and New York. How about the comparison of the electric rates and reliability of service in those two regions? Do you think that the regulatory environment in the Southeast is a contributor to the fact that the Southeast has not only the most reliable service in the country, but also the lowest rates?
Honestly, I haven't looked to see. I mean, the large coal-burning plants are their primitiveness also means they break down less some, and so I don't know how much of that's correlated. And I've never compared, like, Duke Energy's performance in Southern companies to see if you can make comparisons over both about rates, levels of reliability. So I don't know. I'm not really sure.
Now, I was thinking more at different regions of the country. California is always considered to be sort of the model. And if you take a look at California's history of regulation and energy supply over the last 20 years, some people might reach a different conclusion.
Right. Well, I mean, there's no doubt that there could be a tension between, energy supply goals as the sole goal, and perhaps reducing greenhouse gas emissions. In other words, and so somehow finding the sweet spot where you are both dealing with environmental externalities that may be substantial and also supplying energy in a way that is reliable and perhaps affordable is a substantial tension. I mean, the reality is that I think economists, if you go to economists, they would all say we should all pay much more for our energy, right? In other words, that to say energy is low cost is not something economists would say is right, because there's so many externalized costs of energy none of us bear the cost of, and it'd be far more efficient to pay people of low incomes, basically, direct money to them, but make energy high cost so people will realize what they're using. So I think that's left, and people don't want to talk about it at the federal level, but that is, if you just look at the economics literature, that would be the solution of probably 99 out of 100 economists who are not being paid by the power company. But so I'm not sure where we go with that, but I don't think you're equating low cost as a good. I think many people would debate.
How about reliability of service, since this is a rather critical part
of the
country's life?
That's a huge issue, and I think actually where I find it toughest when you start looking at the need with renewable energy portfolios and the increased use of the energy bills and the rest, and the need for transmission lines to make areas more reliable and basically resilient, that's where it gets toughest when you're thinking about the siting issues, as previous panels have talked about. I think that's an issue. I don't know enough about California where the reliability problems are what they're based on, whether it has to do with climate and heat or lack of water. I don't know the details there.
Okay, we are running a little bit over time, so it is time to head out to lunch. I hope that this panel has set the tone for the rest of the day and given us issues that we can return to regularly. Thank you.